My name is Lauren Briscoe, and I'm an officer with the Nassau Academy of Law Advisory Board. And I want to welcome you all to today's program. It's coordinated between the Adoption Law Committee and the LGBTQ committees at the Bar Association. Before I introduce our speakers today, I would like to introduce our sponsor for today's program. This is a longtime Nassau County Bar Association corporate partner, and its champion offices. I'd like to give Roger Kahn a few minutes to tell you about his services. Roger?
Good afternoon, everybody. I'm Roger Kahn, and my company is Champion Office Suites. We're located on Franklin Avenue in Garden City, and we provide office space by the hour, by the day, by the week, and by the month. And what this means for people who use us, they get everything that they expect from an office and less. In fact, a lot less. They get less cost, they get less inflexible terms, they get less requirements relative to term. Most of our clients are month to month, less concern with management of their office space. In fact, there is no concern with repairs, keeping equipment upgraded. That's all our headache, and we deal with it. I'm going to put my contact information into the chat. If you're interested in this extremely cost-effective alternative to traditional office space, maybe you have a home-based practice, maybe you have a lease that's coming up and you're tired of paying large sums of money to your landlord, maybe you're negotiating out of your lease because you're finding that you're not in your office at all during the pandemic. We're the answer. Very inexpensive, very professional space, close to the courts, which is great, especially if people want to just come in for a meeting before court, during court, after court with their client. We are right there and a very convenient location for you to come to. As I said, my contact information will be in the chat. Please reach out to me if you have any questions or if you know of someone who might be interested in our services. Thanks very much.
Thank you, Roger. Thank you very much. And thank you for your continuing and enduring support of the Bar Association and the Academy. It really is truly appreciated. So now I'm going to introduce our panel for today's program. This is a program called Understanding the New Child Parent Security Act and Second Parent Adoptions. I'm very excited about the program. So first we have Faith Russo. She's our chair of the Bar Association's Adoption Law Committee and has a practice devoted to private agency, step-parent, and second-parent and adult adoptions. We also have Joseph Milizio. He leads the Vishnick McGovern Milizio Business and Transactional Law Exit Planning for Business Owners, LGBTQ Representation, Surrogacy, Adoption, and Assisted Reproduction Practices. And then rounding out our panel today is Melissa Brisman. Melissa has been a pioneer and is a leader in the field of reproductive law. Since 1986, she has drafted legislation and argued before the state Supreme Courts, setting the laws and protecting parental rights for children born through assisted reproduction. During the program, please listen for a code or codes throughout the program and write them on your CLE sign-out sheet. We'll also put the codes in the Zoom chat after they are read. Please also keep your mics mute and videos closed so as not to distract from the program. And please submit all questions through the Zoom chat function. On behalf of the Nassau Academy of Law, please enjoy the presentation. Thank you. Faith?
Yes. Hi, how are you? Good afternoon, everyone. I believe that we're going to start this program with, I believe Joe is going to start and give us an overview of the act and how it will go into effect. And then we'll follow with Melissa, and then I'll finish up the program. And then we could have some questions and answers.
Excellent.
Okay, great. Thank you, Joe.
Thanks, Faith. And I understand that we only have an hour here. So unfortunately, an hour is just not long enough to go through all of the ins and outs and the particulars of this new law. But we are going to do our best to give everyone an understanding as complete as possible of the parameters and some policies and procedures, hopefully, as well, together with how second parent adoption still comes into play with respect to adopting children, et cetera, et cetera. But for now, I am going to present on the Child Parent Security Act. And New York has been and continues to be one of 3 states, together with Louisiana and Michigan, which still outlaws the practice of surrogacy. That will all change, however, on February 15th of this year, due to the passage of the Child Parent Security Act in April of last year. So as of February 15th, New Yorkers will now be able to arrange and carry out surrogacy contracts. But it's been almost 30 years since we have not been able to practice law in this area. So I did want to give some background, because most of us, in all likelihood, have never had any experience, at least in New York, with surrogacy agreements and procedures. So New York actually outlawed surrogacy in 1992 by the enactment of domestic relations law, sections 121 to 124. And those sections essentially declared all agreements for surrogacy void and unenforceable. And the concerns at that time were that people were going to be, for lack of a better term, baby selling, in that a mother would become pregnant and arrange with a intended parent or a third party to transfer parental rights to the third party in payment for a set sum. And the legislature decided that that was not something that they wanted to continue. Essentially, there were problems, or they thought that women would be exploited, especially poor women. They looked at the rights of the surrogate to control her body, termination of parental rights, perhaps without statutory prescriptions, and a very important case in New Jersey by the name of Matter of Baby M. Matter of Baby M can be found at 109 New Jersey 396, a 1988 case. And that case involved the egg of a surrogate, which was fertilized by the sperm of the intended father. It's different from what we're dealing with in New York now, but nevertheless, the results at that time were very interesting. The contractual agreement between the parties was that the intended father would pay a sum of $10,000 to the surrogate once the child was born and was given over to the custody of the intended father. However, after the child was born, the surrogate and her husband, keep in mind that the husband is the presumptive father and therefore needs to be a party to an agreement with respect to the new law. The surrogate's husband refused to consent to the contractual adoption, and the couple actually took the baby to Florida. There was a lawsuit in New Jersey, and the New Jersey court declared the surrogacy contract null and void, claiming it was a contract for the sale of a child, or at the very least, the sale of a mother's right to her child. But the court also affirmed the trial court's ruling and said that the intended father, keep in mind the term intended father means the party who ultimately seeks to have custody and to be the parent of the child. But they said that the intended father, as the biological parent, was entitled to custody because it would be in the best interest of the child. But the court also ruled that there was no termination of the surrogate's parental rights, and she was entitled to visitation. The 1992 DRL laws provided that there are no sanctions for entering into a surrogacy agreement, especially when there was no payment involved. Payment was expressly forbidden, but the only repercussions were a civil penalty to the parties participating in the arrangement of $500. The DRL section 124 did provide that in any legal proceeding between the surrogate and the genetic parent, the court will not consider the surrogate's participation in a surrogacy agreement as adverse to her parental rights. So that's important because the court would look at the surrogate as being a co-parent as well. The harshest penalties, however, were given to people that had any kind of a participation in a surrogacy arrangement. So if you participated in the inducement, arrangement, or assistance in the formation of a surrogacy agreement for compensation, a civil penalty of up to $10,000 and forfeiture of any other payments such as legal fees resulted. And upon the second violation, it was deemed to be a felony. Hence, the majority of us have absolutely no experience in New York with surrogacies because we don't want to lose our license to practice law over it. But that has all changed. And what we have now are significant changes to the law through the enactment of the Family Court Act, Article 5C, which I've included in the materials, and that is termed Judgment of Parentage of Children Conceived Through Assisted Reproduction or Pursuant to Surrogacy Agreements. So that's the law we're really looking at now for our guidance, but there are also changes to other statutory provisions in New York, including the Domestic Relations Law, the Family Court Act, the Public Health Law, the General Business Law, the Estates, Powers, and Trust Law, the Social Services Law, and the Insurance Law. And we'll go through or we'll touch on the parameters of the new law that resulted in the changes to all of those statutory requirements as well. So what we're really dealing with in the new law is something called gestational surrogacy. So there are two types of surrogacy arrangements, essentially. There's gestational surrogacy or traditional, or what is otherwise known as genetic surrogacy. And gestational surrogacy is the process by which a fertilized embryo is implanted into a gestational carrier. So the result is that the carrier bears absolutely no genetic relationship to the child. A traditional or genetic surrogacy, on the other hand, the surrogate acts as both the genetic and the gestational carrier. So she is obviously genetically related to the child, and that process would require artificial insemination or IVF, and the surrogate would need to relinquish control and custody of the child after the birth. What New York allows is gestation, or what New York will allow is gestational surrogacy only. DRL sections 122 and 123 still prohibit traditional surrogacy, and the Parent-Child Security Act allows gestational surrogacy. Now, from my perspective, there's no real reason for the distinction other than perhaps the fact that the legislature was very concerned still with respect to those requirements or observations from 30 years ago, that it would be deemed to be selling a child that a surrogate who was also the genetic parent might be carrying. But there's really no references that I found as to why one is allowed at this point and why one is not. But that's what we have, and that's what we're dealing with. And by the way, there are a lot of unknowns at this point that still have to be worked through, and we can discuss those a bit as well. But hopefully, as time goes on, we'll come to a better understanding of the process itself. And hopefully Melissa can guide us a little bit with her experience in New Jersey before the end of our seminar today. So what are we dealing with when we're looking at representing a client who might either be the intended parent or parents or the surrogate herself in New York? We're dealing with two things, essentially. We're dealing with the surrogacy agreement, and we're dealing with the court proceeding. So first we have the surrogacy agreement. And this is very detailed, very, very lengthy. There are all sorts of protections put in, for the most part, for the surrogate's protection. And the details sort of go on, but I'll go through them in summary form with you so that you're aware of what we're looking at in preparing surrogacy agreements, or perhaps reviewing them on behalf of a surrogate. So the surrogacy agreement is essentially a contract which provides that the gestational carrier and her spouse, if she is married, are parties to the agreement, and the intended parents are the other parties to the agreement. Now, in general, it provides for rights and obligations between the parties. The surrogate's responsibilities being agreeing to attend medical appointments, to maintain a healthy lifestyle, to maintain contact with the intended parent or parents, and of course, an agreement to undergo an embryo transfer and to relinquish any claim to parental rights of the resultant child. The parent's responsibilities, on the other hand, are to pay the basic fee or a basic fee, assuming that a fee is going to be paid, which I would anticipate would be the majority of cases, together with any expenses that are required to be paid. And the expenses come to a pretty lengthy list. So the intended parents would have to pay for maternity clothing, time away from work, travel, living arrangements, a whole host of expenses that are negotiated and which the surrogate can ask for. The agreement itself also outlines potential risks and liabilities. It might cover things such as what happens in the event of a C-section or a miscarriage, with certain provisos that I will get to in a minute. It also includes items such as what IVF clinic will be utilized for the implant, what medical practitioners will be utilized. It will include non-legal provisions, such as the amount of time that the surrogate would have to maintain celibacy. For those of you that are interested, I understand it's 2 weeks before each embryo transfer as the standard. The agreement would also include confidentiality provisions, so that if the intended parents wanted to go on social media and make an announcement, as an example, it might either allow that or not. And then there are things that are ancillary to the birth, such as breast milk pumping. An agreement might contain a provision whereby the surrogate agrees to pump milk on behalf of the baby post-birth, and the period of time that the surrogate would do that, together with any payment for the surrogate's expenses in doing that as well. So in sum, the parties to the surrogate agreement must be at least 21 years of age. At least one of them, and I'm talking now about both the intended parents and the surrogate, at least one of them must be a U.S. citizen or a permanent resident. At least one of them must be a resident of New York State for at least 6 months. If at least one the surrogate must be a resident of New York State for at least 6 months if one of the intended parents is not. But if one of the intended parents is, then the surrogate does not have to be a resident of the state of New York. A complete medical evaluation is necessary prior to any procedures or any medical procedures being done, or any drugs or prescriptions being undertaken. The surrogate is entitled to be represented by independent counsel of her choosing, which is paid for by the intended parents. By the way, any expense, anything that the surrogate is entitled to, for the most part, is always paid by the intended parents. The surrogate will obtain a comprehensive health insurance policy prior to commencing treatment or to taking any medications. And that health insurance policy, again, is paid for and set up by the intended parents. A life insurance policy is involved, and the Commissioner of Health can make any further decisions with respect to what the surrogacy agreement needs to contain in New York. Now, from the intended parents' perspective, they also need to be represented by independent legal counsel throughout the contractual process and throughout the duration of the contract term and its execution. Now, the intended parent or parents can be one unmarried adult, or a married couple together, or two adults who are not married but who are partners. And the exception to the married couple provision is if you are living separate and apart for at least 3 years, or pursuant to a separation agreement, which is either court ordered or in a form suitable for recording. One of the most important provisions of the surrogacy agreement and the surrogacy arrangement itself is an escrow arrangement. If there is payment of compensation involved to the surrogate, then the funds for the base fee and any anticipated additional expenses must be placed in an escrow account, but not like we do for our real estate transactions. The escrow agent has to be an independent party. The escrow agent also has to consent to the jurisdiction of New York courts for all proceedings regarding the enforcement of the escrow agreement. So what this means is that neither of the attorneys representing either of the parties in the surrogacy arrangement can act as the escrow agent. It can be a surrogacy agency, or what's commonly referred to as a surrogacy program, acting as the escrow agent. If the agency is owned by an attorney, that would be fine. But if it's not owned by an attorney, then the agency would have to be bonded and insured in order to accept the escrow. And I hope that Melissa can give us some more practical experience on this. But obviously, there will be issues that need to be addressed in the surrogacy agreement itself to provide for what happens in the event of a termination of the pregnancy, et cetera, et cetera. I assume that the surrogacy arrangement, together with the escrow provisions and agreement, would provide for payments over time that would terminate upon the happening of certain events. The surrogacy agreement must disclose how the intended parents will cover the medical expenses for the surrogate and for the child. If a health insurance policy is used, the disclosure must include a review of the health insurance provisions, the coverage provisions, and any exclusions. The agreement, interestingly enough, must include the first and last names and contact information for the donors. And what we mean by the donors are the donors of the genetic material that creates the embryo. So again, we're dealing only with gestational surrogacy, so we need to have a fertilized embryo that the surrogate carries throughout the term of the pregnancy. And the surrogacy agreement, for some unknown reason, requires the information with respect to the donors, unless it's an anonymous donation, in which event the agreement does not have to reveal the information. In any event, the surrogacy agreement also has to include the surrogate, her spouse, if she is married. It includes, obviously, a statement that the surrogate agrees to undergo an embryo transfer and will attempt to carry and give birth to the child. The acknowledgement that the surrogate and her husband, if applicable, will surrender custody to all resulting children as a result of the birth. The agreement needs to include names and informations of the attorneys representing both parties, as well as a reference to the Bill of Rights. Bill of Rights is something that is also a part of this new law, and the Bill of Rights essentially has to be incorporated into, at least by reference, the surrogacy agreement, and we'll get to that in a minute as well. As to the intended parents, we need to provide in the agreement that they will accept custody and support of all resulting children immediately upon birth, regardless of the number of children, the gender, or the mental or physical condition of the children. It also must incorporate the rights and obligations of the intended parents as being non-assignable. So you can't do this, again, as a real estate contract and assign your rights under the surrogacy agreement. Now, obviously, the agreement has to include a provision regarding compensation, and the law is both specific and very vague with respect to compensation. Part 5 of Article 5C of the Family Court Act governs compensation. And essentially what it provides is that compensation may be paid to a surrogate based upon medical risks, physical discomfort, inconvenience, and the responsibilities they are undertaking in connection with their participation in an assisted reproduction. Compensation must be reasonable and negotiated in good faith and shall not exceed the pregnancy and 8 weeks after the birth of the child. I'd love to hear again what compensation looks like in this day and age. 30 years ago, that $10,000 number seemed to be the number that all of the cases refer to, but I understand at this point that it's more like $30,000 or $35,000, and if an agency is used, all of the fees can add up to $125,000 to $175,000 or more. The Bill of Rights that I mentioned before is also very specific. The Bill of Rights cannot be waived. Any attempt to waive it is void as against public policy. And the Bill of Rights essentially provides that any agreement that the surrogate makes has to include a provision that she is entitled to make all of her health and welfare decisions, including whether to terminate the pregnancy or to terminate a certain number of embryos. She also has the absolute right to determine preconception care, prenatal care, major medical treatments, hospitalization, behavioral health care, and that extends for 12 months after the birth of the child. It includes behavioral and psychological counseling. And it also includes a life insurance policy in the minimum benefit amount of $750,000, or a maximum amount that the surrogate can be covered for if she cannot be covered for $750,000 of insurance. It's important to note also that the surrogate and the spouse of the surrogate and the intended parent or parents can terminate the surrogacy agreement before the surrogate becomes pregnant, simply by giving notice of termination of the agreement. Again, the compensation would have to be worked out pursuant to the provisions of the surrogacy agreement. If the surrogacy agreement doesn't meet the material requirements of the act, then the agreement is non-enforceable and the court determines parentage based upon the intent of the parties and what's in the best interest of the child. But an intended parent's absence of a genetic connection to the child is not a sufficient basis to deny the individual's legal parentage. So even though the intended parent is not genetically related to the child, they can still be deemed the legal parent. That's the first half. I have about 1 minute to give you the second half, which is about the legal proceedings necessary. And pursuant to the Family Court Act, Section 581-206, proceedings relating to judgments of parentage may be instituted in the Supreme Court, the Family Court, or the Surrogates Court.
Okay.
So it's
Excuse me, Joe. I don't mean to interrupt you. We only have an hour, so I don't want to interrupt, but maybe we could have Melissa speak and then you could finish up if we have more time.
Sure.
I'm getting the heads up from Jen. I'm sorry. I apologize.
Absolutely. So Melissa, why don't you,
Thank you.
Come in and give us your expertise.
I'm talking to the wall, I could see, because I was on mute. I apologize. So I would be happy to give you practical. I did give out the PowerPoint. Does everybody get that, the PowerPoint?
Yeah, I believe it was distributed as supplemental documents. Yes.
Sure. So just to have a little bit of background of where I'm coming from, and I'm going to give you some practical advice. So I started doing surrogacy really when nobody else did. I had a practice exclusively for gestational surrogacy arrangements in 1999. My office has completed over 5,000. So I'm also the CEO of an agency in addition to my law practice, and we have about 100 pregnant carriers at any time. So I have a different perspective on a lot of these procedural aspects. So one of the things once New Yorkers start getting into this kind of law, they'll have contact with a lot of different states, because it's fairly common that the intended parents and the gestational surrogate do not live in the same state. So what you're going to find is that almost nobody is going to want to choose New York as a choice of law if they can avoid it. Rather than really going through the whole statute, which I think Joe did very well, I just want to point out what's extremely unusual in this field, meaning there is no other state that has a provision like this. So I always like to start with, I counted, if we can all count that high and not get bored, it's 56 pages, the Child Parent Security Act legislation. The average legislation, for instance, I was on the committee for New Jersey. The legislation that we passed is approximately 4 pages. So there's a lot of conflicting information. There is right now going through a cleanup stage with the governor's office that we actually have a meeting about tomorrow, because they have not issued any of the forms. Department of Health is supposed to issue forms, which I'll get to later, so that clinics know exactly how to proceed on February 15th, and they are not close to issuing those forms. Agencies are supposed to be licensed in order to practice. There's no licensing form up. So none of these things have been done so that anybody knows realistically what to do. And given the COVID situation in New York, it's obviously not a high priority on the governor's desk to issue these forms. But having said this, the Surrogate Bill of Rights, which allows a surrogate to have control over her body, isn't that unusual. What's unusual is it is unclear in the statute that if the surrogate doesn't do what the intended parents want, in most states there can be a penalty. In New York, it seems there cannot. Meaning if a surrogate agrees to have a C-section if the doctor recommends it and she doesn't have a C-section and the baby dies, there would obviously be monetary liability possibly. It seems upon a reading of the Child Parent Security Act that there is no liability. She doesn't have the C-section, she still gets paid. The agreement is enforceable. That's her choice not to have the C-section. Same thing goes for abortion, reduction, letting the parents in the room, all the things that we normally have in a surrogacy arrangement. The other things that are quite unusual, and actually one of the changes in here is one that I fought for pretty hard, was that it says that there should be a minimum of $750,000. I actually wrote a letter that it is nearly impossible to get a $750,000 policy on someone who doesn't work. A lot of these women who are doing it for compensation are stay-at-homes, and the length and the number of exams required to get $750,000 on somebody who doesn't have that kind of income to replace is very hard. So you'll notice in the statute it says, or the maximum up to $750,000 that the life insurance company will issue. However, things like health insurance, life insurance, mental health counseling, legal fees, they're unlimited. There are no caps. So, and they're a year after birth. This is what's really unusual. So according to the agreement, it is unclear in the statute if the surrogate breaches the agreement and she needs legal counsel during up to a year after birth, it seems that her lost wages and her legal fees should be reimbursed under a reading of the statute. So these things are very unclear and make it, I think the idea was to try to get this passed by a lot of feminists who thought they were not, this was not enough protections for the surrogate. But I think what it did was it opened up, fertility clinics cannot do transfers right now on paid surrogates. So basically what it did for New Yorkers was wonderful. They can now use their own doctor. They don't have to move their embryos. But in my opinion, it didn't open up the world of New York surrogates because a lot of people are going to be afraid to use a New York surrogate because, as Joe said, this is already $120,000 to $175,000. $35,000, by the way, is on the low end. Surrogates can get $50,000, $60,000. So if you're having a $150,000 arrangement and the surrogate is having control over all the medical decisions, and now you got to pay another $30,000 for all these things at the end, there's not going to be, I think, a big demand. People are going to want to go to New Jersey. They're going to want to go to Connecticut. They're going to want to go to other places. So I think as a lawyer, one of the things we have to examine, and then I put in my slides, is the choice of law, right? So if you have a New Jersey couple, under the New Jersey statute, you can actually get the parental order where the parents live in New Jersey. So if you have a New Jersey couple using a New York carrier, you certainly can use the New York clinic if the New York clinic wants it, but I think it's probably to your benefit to have a choice of law provision in the agreement and have New Jersey law govern, because if your parents are the intended parents, they're not going to want all these unusual outside the industry things that were put into the law to make it pass, and we're not fully vetted. So that's one of the more practical things. So the other really practical thing is I advise a lot of clinics. I've set up a lot of programs. Actually, 20 years ago, I set up RMA New Jersey's gestational carrier program. It was one of the first around here, and I help with the consent forms and the management. This is really, really hard because how can I tell a clinic, or any of us tell a clinic, what to do legally when it says you have to fill out all these forms in the statute and none of them are anywhere to be found, right? So there's no form you can get right now from the Department of Health. You can't license yourself through the Department of Health. And the clinics are going to be flying blind. The other issue is that the clinics are not lawyers, and even lawyers are completely confused. for about a month after this was passed, I read the law every night to see how is this gonna work? Like I read like 2 or 3 pages, took notes, did it again. I found a ton of inconsistencies which are still in the bill that don't really make sense. You'll notice that there's a couple of times where the recipient of an egg donor is called the gestating mother, right? Because she's the mother and she gets an egg donor. And there's a couple of times in the statute where they accidentally call the gestational carrier the gestating mother. So making the statute even more confusing. But having said that, when we go to New York, so it says that a New York clinic must give a carrier the surrogate bill of rights. That's something that Joe went through. I actually have the entire surrogate bill of rights on different slides in the PowerPoint if you want to look at it. The surrogate bill of rights tells the surrogate everything that she's entitled to under New York law. That's a requirement that the doctor give the surrogate bill of rights. However, if the surrogate is entering into an agreement with parents under Connecticut law or New Jersey law, because they are legally allowed to choose that law because the parents live there, the surrogate bill of rights doesn't apply, and she's getting a bill of rights from her doctor because it's required by law, but her agreement and arrangement isn't under New York law, so it doesn't make any sense. So I think it's going to cause confusion, and once surrogates get those bill of rights, they may want some of those things that are in there that are non-standard, right? So if you just think about it, if the gestational surrogate gets health insurance from her job through her husband's employer, and she has to pay, $200 a month, that's not a big expense to ask the parents to pay for another year. However, if we go on the open market during Obamacare, or one of the great things about New York is that under New York law, on the day somebody becomes pregnant, you can actually get Obamacare. That makes it a good state for surrogates in the sense that if they don't have insurance, you don't have to pay for it technically before, although under the statute you do. But in general, you can get it the day you're pregnant. But some of those plans could be $700, $800 a month with a $5,000 deductible. So if you're talking about paying that for an extra year, the health insurance alone is adding $15,000, $16,000 onto their case. If they claim they need psychiatric care, there's no way to know because you don't have access to the records whether the psychiatric care is for postpartum depression or just they need it and they want to use it. They can go to anyone. It doesn't have to be under their health insurance. For a year, they could pay $500 a week to a top-notch, social worker, psychiatrist in New York, adding another, $25,000 to the arrangement. This is in the surrogate bill of rights. We choose New Jersey law. Like, how is that going to work? So if the New York clinics are supposed to be, it's strange to me that a New York clinic should be advising somebody on the law, right? I would not be happy if the state told me to start advising the surrogates on how likely they are to become pregnant, right? So why the surrogate bill of rights is being distributed by the healthcare professional doesn't really make sense either, but I don't think that's going to change during the process. The other thing that is also very unusual and just something that I know about this bill, which makes zero sense also as a far of legal liability. I won't do a contract where the carrier hasn't been psychologically screened. It's against the ASRM guidelines. It doesn't seem that there's a huge risk if a carrier and the parents haven't been psychologically screened. It is not a requirement under the New York law. So, the surrogate could go to a clinic that doesn't do this a lot. She could be not psychologically screened. She could have had serious mental health issues in the past that were not disclosed. And obviously without a psychological exam, the parents could not know, and there could, be a problem at the end. The other thing that is extremely unusual, so just practical aspects of the bill, is that in all my retainers, I will not entertain a gestational surrogacy contract under any circumstances if the carrier has not given birth. I have been doing this for a very long time. The only case that I had was involving sisters, in which the sister hadn't given birth, and it was a colossal mess when she gave birth. It was a long time ago before we had guidelines, and I wish when I look back that I didn't do the contract. I only did the contract for that case They were in litigation for 7 years. And it's a problem psychologically when someone hasn't given birth before and is not a parent. They don't know what to expect. They can have serious postpartum depression, just like anybody else can. And every other statute that I know of requires the surrogate to have given birth before. This is extremely, extremely unusual. And in your practice, I would say that I won't do it, that doesn't mean you can't do it. It's not illegal. But if you are going to do it, you're going to need some kind of waiver that you are not going to be responsible for any litigation, then it's strongly against your advice to be using somebody who has never given birth before or who's somebody that doesn't have a psychological exam done on them. Also, some good things about the statute, which are very unique to New York. So instead of just complaining the entire time, and I'll wrap it up, and you could always, my contact information is on the slides, and you could always call my office anytime. We have a staff of 20 that, we're always happy to answer other attorneys' questions. But basically, one of the things is that you can, in most states, one person has to be genetically related. Some states, they have to be married. Here, you could be a single person and the embryo could be donated. So that's good. And the very good thing also is that if you are in the process of getting a divorce, but you have been legally, or you've been legally separated and have a legal separation agreement for 3 years, you can enter without the consent of your husband. The last thing I want to say, which we don't have time to go over, is that there are some other really good things in the Child Parent Security Act that have nothing to do with surrogacy, like being able to use embryos after a divorce without holding the ex-spouse parentally responsible if the agreement is executed. So it is worth a read. Probably something to do at night, but it is worth familiarizing yourselves with those other provisions of the agreement.
All right. Thank you so much, Melissa.
Yeah, I'm sorry. I tried to talk super speedy, so I definitely am available if anyone has questions or wants to call the office.
Great. Thank you so much. I really do appreciate you joining us today. Before I even speak, I need to read the code. The code is the word home, HOME, and the numbers 011321. Okay, it's home 011321, and we will put that in the chat as well. So it appears that I have about 3 minutes to speak. So I'm going to jump in quick so we can answer some questions. What I was going to address was the judgment of parentage. Traditionally, in same-sex couples, we file second parent adoptions. And the reason we've been filing second parent adoptions, even if the couple is married at the time of birth, and if the couple is married at the time of birth, under New York law, there is a presumption that both parents are the legal parents. The reason we still file these second parent adoptions is to establish a relationship between the non-biological parent, a legal relationship, and the child. In the United States, we have full faith and credit. So when every state wasn't recognizing the same-sex marriages, at least we know if a family goes from New York to Florida or somewhere else, the non-biological parent would be protected. Our understanding is they put this in the CPSA to eliminate the necessity of second parent adoptions. So we could file a petition for a judgment of parentage, and before birth, it could be filed. And the court can even sign it. It just does not go into effect until when the child is born. Okay, so if you have same-sex couple, you could file a petition asking for a judgment of parentage. And what this mechanism will do is that it will establish parentage for a child born from assisted reproduction. It declares the intended parent's legal parentage without an adoption process. Why wouldn't we want a second parent adoption process? Why did they put this in? A, it's costly. It could cost $4,000 or $5,000. Two, the other thing is it's very evasive. The second parent adoption, the non-biological parent, who is the legal parent, based on their marriage to the bio parent, is going to have a home study evaluation, criminal clearances, child abuse clearances, medical affidavits, financial affidavits, 3 letters of references from people who are not related to them, all have to be filed in the court. So they undergo this scrutiny that heterosexual couples typically don't have to go through just to become a parent. And it's interesting, in Nassau County, since we're doing this in Nassau County, Nassau Surrogates Court is one of the few courts where the biological parent is on the petition with the non-biological parent. And it makes 0 sense if you ask me. We're the only county that I'm aware of that we have to file that way. So when I file even a step-parent adoption, so it's not unique to same sex. When I file a step-parent adoption in Nassau County Surrogates Court, they require that the biological parent, in essence, re-adopt their own child. If I had $1 for every time a biological parent said to me, "Why am I adopting my own child? This makes no sense." I'm not really sure. So maybe that's a question to ask over our surrogates court, but that is the process here. So I guess I want to finish this, and I'm sorry I'm speaking so fast. The reason why I've been speaking to a number of my colleagues, and we've been asking the question, 1, where are we filing these petitions? I think that's the question of the day. I will be completely transparent. I did reach out to Judge St. George's office yesterday, I know in the 11th hour, to say, have you been working on this? Consistent with what Melissa told us is not only is the Department of Health not up to speed, our courts aren't up to speed. They don't know. They are evaluating it. I can tell you that. They're looking into it right now. I spoke to Nassau County Family Court today. I spoke to Jeff Carpenter. He's on top of it. They've been in discussions whether family court will or will not accept them. I can tell you other counties aren't sure either. I spoke to Suffolk surrogates and Suffolk families. They're not sure what they're doing. Actually, I also spoke to OCA up in Albany, and OCA and OCFS have not started distributing forms either. So we might be having a part 2 of this when we actually get the process down. My final comment is, once this goes into effect, February 15th, the statute provides, this is section 581-206 of the Family Court Act, that they may be filed in Supreme Court, Surrogates Court, or Family Court. So that's what this new statute's providing. We're not sure yet. The final question is, will we still file second parent adoptions after this is enacted? The colleagues I have spoken to is yes, we most likely will continue to file the second parent adoptions. Why? There are many jurisdictions outside the United States that do not recognize surrogacy. They do not recognize same-sex marriage. And the concern is, if you go to a country, and we're not talking about Russia or Mideast, you go to Russia, France, England, with this judgment of parentage in your hand, and God forbid something happens to the biological parent, it's not clear whether or not they will recognize this judgment of parentage, and we're really concerned about that. So it seems though this might put a Band-Aid on it. Yes, you're automatically going to be on the birth certificate. You won't have to go through this adoption process. But the buzz is in the same-sex community. My colleagues who practice a lot of the LGBTQ work are saying they believe at this point they will recommend filing the second parent adoptions also in addition to it. So that is everything I could say in about 5 minutes. I apologize for speaking so fast. I will also have my contact information in the chat, and if anyone has any questions, I am more than happy to answer them at any time. I believe we have a number of questions. So Joe, if you're okay with that, I'm going to jump in and start reading them. and see if we could answer them quickly.
Sure, absolutely. I just wanted to clarify one thing.
Of course.
The Act does provide that in the event of a dispute regarding the actual agreement, it is Supreme Court that would govern in that area.
Yes. Yes.
Oh,
Melissa?
and there's no specific performance either, so you can't force somebody to comply physically with a surrogacy agreement. Interestingly.
Right. Yes, I think Melissa did address that. I think this question would be best for you. Somebody had asked earlier, what happens if the intended parents change their mind? I know we have discussed.
Sure, I've actually had that happen before. So it was actually a public case. It was Sherry Shepard, who many of you may know. I think she's on a few TV shows like The View.
The View, yes.
But most of us don't watch daytime TV, so we may not. But that's not the point. She lives in Allendale, New Jersey, which is fairly close to my office. She came there to have a baby using an egg donor and her husband's sperm. Very public about it, talked about it on The View, how she picked the egg donor, no secrets, in People magazine. Filed for divorce mid-pregnancy, claimed that she did not want the baby, that she should not have to be a parent, that she's allowed to change her mind. Court ruled in Pennsylvania, this was, of course, that she can't change her mind. I think the same thing will be here. She doesn't have to see the baby, but she has to support the baby, right? I think that, and she was forced to go on the birth certificate. I think you'll see the same thing in New York. The carrier can't back out if it's a legally enforceable agreement. The parents are the parents. So the parents, if they're both in agreement, they can place the baby. So there was a terrible case actually that I wasn't involved in, but somebody in the Academy of Adoption and Reproductive Attorneys, where the parents got into an accident while their carrier was pregnant. The intended mother died and the intended father became a quadriplegic. He took physical and custody of the baby, but he had no way to care for it. So the baby was placed. I do believe he has some kind of open arrangement that he could visit once in a while. But so that I believe that the parents have to take the baby, pay the bills. This becomes problematic, and we don't have much time with my international clients, right? How are we really going to get international jurisdiction? And during COVID, it was quite difficult to get some of them here, and we had to actually go through embassies and hire interim care providers. It was a big mess.
Okay, I have another question for you, Melissa. And we're like playing beat the clock. I'm so sorry. I see that an attorney asked, given that you were saying some of the concerns with the New York statute, the way it is right now, do you think New York attorneys should be well-versed in New Jersey or Connecticut surrogacy law?
Well, I think that they should do their best. If everyone's from New York, you're stuck with New York law, right? There's nothing you could do. If the clinic's in New York and the people are from New York, you know, we all went to law school. We can't just decide we want New Jersey law for no reason. But it's a good idea to know the New Jersey, Connecticut, Pennsylvania, because if one of the parties lives there or has a residence there, it's advantageous to the carrier too, because no one's going to trust a carrier who doesn't have to sign on the dotted line that she's going to do what she said she was going to do. And it's going to make the relationship more tense, I think.
Right. So somebody just asked the question. I don't think I'm going to be able to read the whole last question, but somebody just asked the time frame in filing for the judgment of parentage. It's my understanding you could file it before the birth, or you could file it after, correct?
You could file it at any time.
At any time. Yeah. Yep, it goes into effect at the birth. Okay. All right. So let me see if is there any specific over time? Okay. Did you cover this? Where are second parents adoptions filed here? Yes. So right now, second parent adoptions, which are synonymous with step parent adoptions, are filed in surrogates court in Nassau County. The only thing that is filed, only adoption cases that are filed in Nassau County are foster care cases. Whether or not Nassau family will be accepting petitions for judgment of parentage, I don't know. As I said before, Jeff Carpenter is not sure yet. They've been speaking to the administrative judge, and we will let the bar know. We might even have a second CLA on this topic once Department of Health distributes their forms, OCA distributes their forms, and the courts here determine where we're filing. So we're not really sure.
I found that if you file in family, I've done a lot of birth orders post-birth that you're allowed to do. There's no compensation. I find it a lot easier to file in Supreme because when you file in Supreme, they typically waive the appearance, and the family courts are just all about getting everybody there for some reason.
Right. So our family courts here right now only take foster care cases. So in Nassau alone, in Suffolk, my understanding, it will be going in family court based on Surrogate Whalen's office, who I spoke to yesterday, but that's not in writing. That was just a quick phone call to her office yesterday. That's what I was advised.
I'm just going to jump in here. I mean, this was such an informative presentation. Thank you so much, Faith and Joe and Melissa. And I am looking forward to part 2. I think there's definitely going to be a lot more in this area of law, and I really appreciate it. It was just so informative. Thank you very much.
Great. Thank you. And thank you everyone for attending. I appreciate the good attendance.
It was certainly a pleasure to do the presentation, and the LGBTQ committee will definitely be discussing a extended presentation based upon this act.
That's great. I'll follow up.
All right. Happy and healthy New Year, everyone. Thank you
for coming. Very much.
Thank you. Thank you once again, Melissa.
Thank you.